I wish to inform the Seanad of a significant development in the criminal justice area in this country that has received very little attention. Late last week, the Department of Justice informed the Law Society that the Director of Public Prosecutions had issued a direction to Garda relating to the questioning of persons in custody. The direction was to the effect that a suspect in Garda custody who makes a request for their solicitor to be present during Garda questioning will for the first time be allowed to do so. This is a long overdue and welcome development. It protects the integrity of the criminal justice system and should lead to a decrease or eradication of challenges to statements of admissions given while being questioned in Garda custody. However, a number of issues arise. It is to be presumed that this decision of the DPP is the natural follow-up to the decision of the Supreme Court in DPP versus Gormley, given earlier this year, which provided that a person who requests the presence of their solicitor must be able to receive that solicitor's advice before questioning commences. In that regard, it should be noted that the Criminal Justice Act 2011 already provides for the decision in Gormley, but hasn't been initiated. At least in that case, the Oireachtas has already debated the matter. This direction of the DPP obviously goes much further, though logically so given the comments of the court in Gormley, while the judgment in Gormley expressly did not enter into the issue of a solicitor being present during interviews, as it did not arise on the facts of the case. The comments in Gormley from Mr Justice Clark in particular seem most relevant to the new directive of the DPP. There also appears to be an evident line from some of the recent European Court of Human Rights cases. My concerns are not that this has come to pass, I welcome it, but rather that the Oireachtas has been bypassed in what is a fundamental shift in the rights of people in custody. This direction does not flow directly as a result of a decision of the Supreme Court. It is a decision made at the discretion of the DPP. In that way, the discretion has no force in law, and I can only guess indicates that the DPP will not accept prosecution files on those cases where the direction was not followed. If that is the case, we are then left with a putative situation where the Garda are affording people their present legal rights during questioning, possibly in very serious crimes, but the DPP may not prosecute as the Garda refuse to go beyond what is legally required at present. What I am asking for here, Cathaoirleach, is perhaps the Leader could arrange for the House to be informed as to what exactly has happened and the views of the Minister for Justice in relation to this matter. And I have to say that I find it unusual that such a far-reaching overhaul of the system of justice is to be arrived at by the DPP without either a decision of the Supreme Court directly on the matter or any debate by the Oireachtas.